Welcome to Landmark Chambers webinar. This is the second in the series of the property law nuts and bolts. Today we will be speaking about section 36, part 36 of the CPR. We're delighted to see so many of you joining the session today, and we hope that you'll find the presentations and discussion to be useful and informative. My name is Evie Barden, and I will chair the session today. And I am joined by my wonderful colleagues, Matty Green and Claudia Hyde, who I will introduce in a moment. But just to begin, a few housekeeping points. Your microphones are automatically muted, so you will not need to adjust your local settings. However, we very much welcome questions throughout the session. To do that, please submit them via the text in the Q&A function, which may be found at the top or bottom of your screen. If you'd like to remain anonymous, that's obviously all right. Just please make sure you tick the send anonymously box when submitting your question. We will try and answer as many questions as possible at the end of the presentations, but if we're not able to do so, we will try and follow up after the event. This webinar will be recorded. You will receive a link to the presentation and the recording shortly after the event concludes. If your connection is lost at any point, please try and rejoin the meeting by clicking on the original link once again. So to begin, I'm going to introduce Matty and Claudia. Matty is a specialist property barrister with experience in all areas of real property, residential and commercial and landlord-tenant litigation. Matty enjoys a busy court practice before a variety of tribunals. And during the course of that litigation, Matty is often instructed to consider and advise in relation to offers of settlement. So she's very well placed to talk today about key considerations and recent developments under Part 36. Claudia recently joined Landmark Chambers following the successful completion of her pupillage. She accepts instructions across all areas of Landmark's main practice, with a particular interest in the intersection of public and property law. Her recent property instructions have included matters concerning housing enforcement, mortgage repossession, and residential and commercial landlord and tenant work. So I will now hand over to Claudia to tell you about an overview of Part 36.
Thank you, Evie, and thank you everyone for joining us today. In this section of the webinar, I will be going through the basic what, when and how of the Part 36 rules, including what they are, when Part 36 offers are available, how to make them, and how they actually operate in practice. This talk is deliberately pitched at quite a high level, so much of the content that I cover may well be well known to you already. But in the context of Part 36 offers, as I will cover, it is so often about getting the absolute basics right. So I hope that this will be valuable to everyone, regardless of your experience with Part 36 offers. Now, by way of overview, Part 36 is a provision in the civil procedure rules which fundamentally aims to encourage parties to try to settle their disputes without having recourse to the courts. And it does so by setting out the consequences of offers to settle if they are made in accordance with Part 36, and provides a self-contained procedural code for making, withdrawing, and accepting such settlement offers. Now, turning first to the whats. So Part 36 offers entail prescribed requirements that need to be met in order for an offer to settle to be regarded as a Part 36 offer and therefore compliant, and therefore to carry the prescribed procedural consequences. Those are set out conveniently in Rule 36.5. Firstly, the offer must be in writing, a verbal offer outside the courtroom or on the phone without being backed up with formal written offers will not therefore meet the requirements of 36(5)(1)(a). Secondly, a Part 36 offer must specifically be made pursuant to Part 36. It will normally be headed as a Part 36 offer, so as to make sure it's distinct from, for example, a Calderbank offer or any general without prejudice offer. It must specify a period of not less than 28 days within which the defendant will be liable for the claimant's costs, and you will see that referred to in the rules as the relevant period. That's 36(5)(1)(c). A Part 36 offer must state whether it applies to the whole or part of the claim. For example, if it is in relation to if there are several claims, or which of those it is in relationship to, or if it relates only to a counterclaim, it must be provided with sufficient clarity. And finally, it must state whether it takes into account any counterclaim. Now, so the question arises as to what happens if these technical requirements are not met. Like, it is important not to be caught out by these requirements. So although part of the rationale for introducing the Part 36 scheme was to reduce the number of formalities and technicalities that go into the making and offering of offers to settle, in practice, many offers that are not made in accordance with those technical requirements will not attract the usual consequences. So the question arises, what will the court make of a purported Part 36 offer that does not meet those requirements? Now, it is important to note that non-compliant offers, while they can occasionally be validated, will not be validated as a matter of course. And it was stated in the following terms in F&C Alternative Investments Holdings Limited and Barthélemy No. 3. It is not permissible wholly to discount a number of failures to comply with the requirements of Part 36 as the merest technicality. Perhaps there can be de minimis errors or obvious slips which mislead no one, but the general rule is that for an offer to be Part 36 offer, it must strictly comply with the requirements. Thus, the F&C Alternative Investments case does leave open the possibility that the court will be willing to overlook a trivial or de minimis error, but anyone engaging in litigation would be well advised to take particular care and attention to ensure that those mandatory requirements, particularly in Rule 36.5, are all met, so as to avoid the need for further fights and disputes about who pays whose costs further down the line. Now, parties are not bound to make offers in accordance to Part 36. Those who seek the benefits that flow from Part 36 must make sure they follow the rules. But when is Part 36 actually available? Well, Part 36.2 makes clear that Part 36 offers will be available in the following instances. That include money claims and non-money claims, including claims for provisional damages, claims in respect of the whole or part of the claim, or in relation to an issue that arises, for example, in respect of liability or quantum only. They're available on appeal or cross-appeal from a decision made at trial. They can be made in respect of liability alone, thus leaving the issue of damages to be fought out later, and in respect of counterclaims and any additional or third-party claims. But it is important to note that Part 36 offers are not available in the context of claims in the small claims track. So any offer in the small claims that purports to be Part 36 will not attract those cost consequences. So that is how Part 36 operates if an offer is made and then accepted. The particular costs provisions that accompany Part 36 kick in when an offer is rejected. And those rules are found in Part CPR 3617. And the rules that apply depend on the outcome for the respective parties. So say, for example, that the claimant has made an offer to settle, but the defendant either refused it or provided a counter offer that was rejected by the claimant. Then the claim proceeds to trial and judgment is handed down. And what happens next depends on that judgment. If the claimant beats the defendant's offer, then the rules in Rule 36.17(4) apply. So firstly, the case will settle on the basis of the terms of the Part 36. Oh, sorry, no, that's, apologies, that's what, I forgot to click onto the wrong slide. There we go. If the claimant obtains a judgment, which in the words of the CPR is at least as advantageous as their own offer, then what they will receive is interest at a rate not exceeding 10% above base rate, which is quite a considerable boost to the interest rate. Costs on the indemnity basis, plus interest on those costs, again, calculated at a rate not exceeding 10% above the base. And here's the kicker, the claimant's bonus, or known as the additional amount. That is a sum not exceeding £75,000, which comprises 10% of the award of damages up to £500,000. And if the award exceeds £500,000, then 5% of any sums exceeding that, but capped overall at £500,000. Unless the court considers it unjust to do so, having regard to the factors set out in 36.17(5), which I'll deal with in a bit more detail in a second. It is important to note that the court does retain a residual discretion to depart from these rules where it considers that it would be unjust to make the usual award. The party at risk, so in this case it would be the defendant, is required to establish those grounds, so the burden is on them, the grounds that would render the usual order unjust. And the court is required to take into account all the circumstances of the case, including those factors set out in Rule 3617(5). I have not put all of these in the PowerPoint, as there are quite a few of them. But the factors that tend to come up fairly often in complex litigation are factors D and E. D refers to the conduct of the parties with regard to the giving or refusal to give information. And E refers to whether the offer was a genuine attempt to settle the proceedings. Now, those are important points to bear in mind because they underscore that the court will not usually look favourably on unreasonably lowball offers, for instance, and equally will not look particularly favourably upon parties who withheld information from the other side in order to improve their position going into a settlement. Part 36 is designed to encourage parties to make genuine offers of settlement rather than offers just for the sake of ensuring that the Part 36 provisions kick in. But what happens if the claimant fails to beat the defendant's offer or fails to obtain a judgment that's more advantageous than the defendant's Part 36 offer? Well, in this case, CPR 3617.3 kicks in, and Part 36 prescribes a rather less advantageous outcome for the defendant. And what Part 3617.3 says is that the court must, unless it considers it unjust to do so, order that the defendant is entitled to their costs, including any recoverable pre-action costs from the date on which the relevant period expired, and interest on those costs. And then as to the situation where the judgment matches the offer, ordinary rules apply. Now, what of the situation where an offer has been made, but then subsequently withdrawn? Well, the CPR sets out rules that govern how and when Part 36 offers can be withdrawn by the offerer in Rule 36.9. The first rule is that a Part 36 offer can only be withdrawn or its terms changed and in effect substituted for a different offer if the offeree has not previously served notice of their acceptance. And secondly, if the offerer withdraws the offer or changes its terms by serving written notice on the offeree. So that deals with the scenario where the offer has not been accepted yet. But CPR 3610 governs the situation where the offer has been accepted. In short, if notice of acceptance of the original offer has already been served, then the offerer has to apply to the court for permission. Now, if they seek to withdraw or change the terms. The court will only give their permission if it is satisfied that there has been a change of circumstances since the making of the original offer, and that it is in the interests of justice to give permission. That's the test in CPR 3610(3). Now, such instances of the court allowing that are relatively rare. So for instance, in a case called Warmold and Ahmed, permission was granted to withdraw an offer that had been made 6 years previously, and then only accepted a matter of hours before the death of the offeree. Now, those were quite extraordinary facts, and less extraordinary facts have given rise to a finding that it is in the interests of justice to give permission, but it underscores the fact that such instances will be relatively rare. Now, there is one final matter to cover before I hand over to Matty. The scenarios that I've dealt with so far concern what happens if the offer is accepted within the relevant period, so within 21 days. Different cost rules apply, however, if the offer is accepted after the relevant period, and those rules are found in CPR 3613. So if either party seeks to accept a Part 36 offer after the 21-day period, this can still be done if certain conditions are met. Firstly, the offer has to not have been withdrawn, and the parties then have to agree the position as to the costs incurred by each side from the expiry of the 21-day period to the date of acceptance, failing which the court will determine the cost position. When the court does have to determine the cost position, in that case where a Part 36 offer relating to the whole claim is accepted after the expiry of the relevant period, then CPR 3613(5) makes clear that the court must order that the claimant be awarded their costs up to the date on which the relevant period expired, and that the offeree pays the offerer's costs for the period from the date of expiry of the relevant period to the date of acceptance, again, unless it would be unjust to do so. And then those factors in CPR 3617.5 become relevant considerations again. So that brings me to the end of my whistle-stop tour of Part 36. I will now hand over to Matty to talk to you about recent developments in the case law and key considerations.
Thank you, Claudia, and thank you all for joining us. So as Claudia and Evie have said, I'm going to be talking about some of the key considerations under Part 36, as well as the recent developments. So, and now that you've got the framework, I'm going to focus on some more specific points. you might be thinking, what's the most recent development under Part 36? One of the most significant recent developments is the way in which Part 36 relates to the new rules on fixed costs that were introduced in October of last year. I'm going to come to that at the end, but before we consider how Part 36 applies to claims allocated to those tracks, I'm going to take you through some of the key themes in relation to Part 36 offers generally, so that you can try and avoid tripping up when you're making or considering a Part 36 offer. Sorry, Jasmine, can you do next slide, please? Oh, there we go. So as Claudia has already mentioned, an offer which does not comply with the mandatory requirements of Rule 36.5 will not attract the usual Part 36 consequences. And it might sound obvious, but a common mistake that comes up in practice is to include terms as to costs within the Part 36 offer. So to make an offer of settlement and then state that each party pays their own costs. That isn't how Part 36 works. And so including terms as to costs is inconsistent with the scheme of Part 36. And the authority for that is the two cases that I've put on the first bullet point on the slide. And an offer to pay a global sum inclusive of costs is also not compliant with Part 36, and that's from the French and Groupama Limited case. And as I say, it might seem obvious, but in practice, it actually happens all the time. There's also conflicting first instance authority as to whether a claimant can make a valid Part 36 offer that doesn't require the defendant to pay the claimant's costs. In the Procter & Gamble case, a claimant had made a claimant's offer on terms that it would pay the defendant's costs upon acceptance. And the judge held that it was open to an offeror to forsake its entitlement to costs, so for the claimant to forsake its entitlement to costs, and that the true requirement in Rule 36.51c is that if a claimant seeks its costs, it has to specify a period of not less than 21 days in which they are to be paid. And so in that case, the Part 36 offer was held to be valid. But Procter was doubted in the second case that I put in the third bullet point on the slide, which is Night and Night, where the judge held that he was bound by Mitchell, which is the case in the first bullet point, and French in the second bullet point, to hold that any offer that included terms as to costs was not a valid Part 36 offer. So generally don't include reference to the costs in the offer, because the cost consequences are what they are within the Part 36 regime. And if you're a claimant and you're willing to forego your costs, then it's unclear at the moment. There's conflicting authority about whether or not it would still be a valid Part 36 offer. And as well as terms as to costs, as Claudia has explained, one of the mandatory requirements under Rule 36.5 is that a Part 36 offer must include all interest up to the end of the relevant period, or if the offer is made less than 21 days before the trial for a period of 21 days. And in King and the City of London Corp, it was held that properly analysed, interest is ancillary to and not severable from a claim, so that an offer that excludes interest is not a Part 36 offer. An offer that is stated to be exclusive of interest but doesn't state that interest will be excluded is not invalid, because it's not at odds with the requirement that interest must be paid. So if you say you make an offer of a global sum and expressly provide in the offer that interest won't be paid, then that wouldn't be a valid Part 36 offer. But if you specify that the sum you're claiming doesn't include the interest, then that wouldn't invalidate it. So it's the way you can potentially trip up is by stating that interest wouldn't be payable, because the rules provide that interest will be payable for the periods stated in the relevant part. So that deals with including terms and as to costs and as to interest in the offer, and how that can trip you up making an offer. As Claudia has explained, a valid Part 36 offer must specify a period of not less than 21 days within which the defendant will be liable for the claimant's costs. In Begum and Bart's Health NHS Trust, the claimant asked the court to order that the time for the acceptance of a defendant's Part 36 offer be extended, and that if the offer was accepted within the extended time period, that the defendant would be liable for the claimant's costs in accordance with the provisions under Rule 36.13. The defendant in that case denied that the court had jurisdiction to make such an order, and the claimant argued that the court did have jurisdiction under its general powers in Rule 3.12a, which gives the court power to extend or shorten time for compliance with any rule, practice, direction, or court order. But the court held that it has no power under Part 36 or under Rule 3 to vary the 21-day time limit. And of particular importance was the fact that Part 36 is a self-contained code. So the key takeaway there is that the court doesn't have the power, doesn't have the ability under the rules to vary or extend the 21-day time period. And the court's power in Rule 3.12a isn't a get around for that. There are a number of cases now developing where parties have tried to rely on Rule 3.1 to extend time in circumstances where it's just not what Rule 3.1 was envisaged for. So keep that in mind when you're considering the 21-day period. It won't be extended. And then similarly, the court held in Titmus and General Motors UK Limited that the court has no discretion under Part 3 to extend the 14-day time limit provided for under Rule 36.146 for payment of a Part 36 offer. So again, the rules provide that the sum must be paid within 14 days if the offer is accepted, and there's no power for the court to extend that. Again, reference was made to the fact that Part 36 is a self-contained code with clear rules designed to encourage out-of-court settlements, and that certainty would be undermined if Part 3 allowed the court to extend the time for payment. Oh, there we go. Sorry, jumped a slide. A point to keep in mind when you're considering Part 36 offers is whether or not you should be seeking clarification of the offer. So the rules provide that within 7 days of a Part 36 offer being made, the offeree can request that the offeror clarify the offer, and that's Rule 36.8. And the headline for this point is effectively, if the offer is unclear, do not simply rely on the absence of information to assume that it will invalidate the offer. In fact, in the A, B, and C, D case, it was held that if the offeror fails to seek such clarification, they may later be precluded from arguing that the offer contained insufficient information to be valid. So a sort of an analogous situation is where you're at trial and you complain that the other side hasn't provided a document, but no application for specific disclosure has been made. If you're going to want to argue that the offer is invalid because it's unclear, the response you're likely to get is, well, you should have asked for clarification or sought an order for clarification. Don't just sit on the uncertainty and wait to argue about it at trial, because you may find that you're later precluded from doing so. And that's particularly important where the offer is not just purely on monetary terms, and there is scope for argument as to whether or not it may or may not be more advantageous than the result of the litigated resolution between the parties. So it's one to keep in mind. If it is unclear, don't just sit on that. Ask the question, or if necessary, seek the order for clarification. And then I'm just going to pick up on two of the points that Claudia referred to. So as Claudia has explained, the cost consequences that follow after judgment, where a claimant obtains judgment, which is at least as advantageous as their own offer, or where the claimant fails to obtain judgment more advantageous than a defendant's Part 36 offer. And the consequences that are set out in Part 36 will apply unless the court considers it unjust to make an order in those terms. And in considering whether it would be unjust to make an order, Rule 36, 17, subparagraph 5 requires the court to take into account all the circumstances of the case, including the matters that are listed in the subrule. And those include the terms of any Part 36 offer, the stage in the proceedings when any Part 36 offer was made, including in particular how long before the trial started the offer was made, the information available to the parties at the time when the Part 36 offer was made, the conduct of the parties with regard to the giving of or refusal to give information for the purposes of enabling the offer to be made or evaluated, and whether the offer was a genuine attempt to settle proceedings. I'm going to have a look at some of the more recent cases on whether or not an offer was a genuine attempt to settle proceedings in a moment. But first, looking at some of the cases more generally on whether or not it's unjust to make the usual order that follows from the Part 36 consequences. In Matthews and Metal Improvements, it was held that the question is not whether the offeree had reasonable grounds for not accepting the offer, but to consider whether the usual order would be unjust. So the test is one of injustice. And in the Smith and Trafford Housing Trust case, it was held that the burden on the claimant who has failed to beat the defendant's Part 36 offer to show injustice is a formidable obstacle to the obtaining of a different cost order. And it was held that if that were not so, then the salutary purpose of Part 36 in promoting compromise and the avoidance of unnecessary expenditure of costs and court time would be undermined. If a party has not enabled another party to properly assess whether or not to make an offer or whether to accept an offer because of either non-disclosure of material facts or if a party comes to a decision which is different from that which it would have reached if there'd been proper disclosure, then that is a material consideration for the court when deciding what orders to make. And a relatively recent example is the head and the culvert heating, where a decisive factor when considering all the circumstances was the late introduction of the claimant's evidence. But I've included two cases there on the slides at the bottom, which demonstrate the exceptional circumstances in which the court may depart from the usual orders. In the Novus Aviation Limited case, it was held that it would be unjust to make the usual order where the sterling value of a US dollar judgment only exceeded the claimant's Part 36 offer because of dramatic currency fluctuations following the Brexit vote. And in the London Trocadero case, the judge held that the wholly exceptional circumstances created by the COVID-19 pandemic meant that it was unjust to order all of the Part 36 consequences in that claim for rental arrears. And so the judge concluded in the London Trocadero case that there would be no award of the additional amount or the claimant's bonus under Rule 36.174D, in addition to the rent arrears. And it was also held that it would be unjust to award the claimant an enhanced rate of interest on the rental arrears. So the sort of the relevant rate applied rather than an enhanced rate. But those two cases are quite interesting because they show the sort of the circumstances in which it will be unjust for the court to make a rule that departs from the normal cost consequences. And I just thought it was quite telling that one of them was Brexit and the other one was COVID. And then finally, on the circumstances in which the court might consider that it's unjust to make the usual cost orders, one of the factors that has to be considered is whether the offer is a genuine attempt to settle the proceedings. And this is a case that I've already referred to, and you may be familiar with because it's a relatively old case, although the other cases I've referred to are more recent developments. But in the A, B, and CD case, the claimant sought an order on the basis that it had succeeded in full and thereby obtained a judgment at least as advantageous as a Part 36 offer seeking 100% recovery. And in that case, the judge refused to order the Part 36 consequences, observing that the concept of settlement involved an element of give and take, and that a settlement offer must involve some genuine element of concession. And he criticised the offer in that case as a demand for total capitulation. So paragraph 5E that we're referring to was added with effect from the 5th of April 2015, so after this case. And that was to deal with the problem of claimants making very high settlement offers that weren't a genuine attempt to settle the proceedings, but just to put the defendant at risk of indemnity costs. In the yield point stable value fund case I've just referred to there, it's a relatively recent case, some guidance on how to approach paragraph 5E was given. And it was held that it was important to remember that the default rules are only to be departed from where such orders would be unjust, and that, as I referred to already, the offeree faces a formidable obstacle in obtaining a different order. Paragraph 5E is a useful consideration in cases where claimants have made very high Part 36 offers, but judges are likely to resist attempts to call evidence or obtain disclosure on that point. And they will be able to take a broad brush approach, largely informed by their own assessment of the strengths of the case that they have just tried. And therefore, they will have, they'll be able to consider their assessment of the strengths of the case and how that affects whether or not it is a genuine attempt to settle. The two cases that I've listed on the slide demonstrate that there's nothing inherently wrong with very high claimant offers in extremely strong cases. But a practical point would be to explain in offer letters, if you're acting for a claimant and you're making a very high offer, is to explain why such a small discount is being offered for settlement. So justify it at the point of making the offer, as opposed to just seeking 99%, or only offering a 0.3% discount, which is what happened in the Royal Bank SA and Travelex Banknotes Limited case. In that case, a Part 36 offer for 99.7% of the claim was deemed a genuine attempt to settle, given the merits of the claim, a complete lack of defence, and it being considered that any discount would involve the claimant giving up something which it had a clear, near certainty of obtaining. However, in that case, other circumstances of the case meant that not all of the Part 36 consequences applied. In the yield point stable value fund case, the court held that individual decisions on particular percentages cannot inform or dictate how a judge should evaluate an offer before him. So because an offer for 99% of the claim was held not to be a genuine attempt to settle in one case, doesn't mean that anything over 95% will never be a genuine offer to settle. And in fact, the Royal Bank case is quite a good one to point to for that. Although it's sort of restating the point that comes up all the time in litigation, which is that each case has to be considered on its own facts. In the yield point case, as it happens, a 99% offer was not a genuine attempt to settle, and it would be unjust for the usual orders for Part 36 to apply. So that's sort of a run through of some of the key provisions, or key points, key takeaways from the points that Claudia is taking you through on Part 36. One of the key developments to Part 36 is in relation to proceedings that were issued on or after the 1st of October 2023. Part 36 has been updated to reflect the introduction of fixed recoverable costs for fast track, intermediate and intermediate tracks, claims that were introduced on the 1st of October of last year. They also have provisions in relation to noise-induced hearing loss cases and personal injury cases. I'm going to assume that if you're here, it's because you do work in property litigation, so you probably don't need to worry about those too much. But what you do need to know is that a new Section 2 was introduced into Part 36. And that deals with the cost consequences of Part 36 offers being made and accepted or beaten at a trial for cases that are allocated to the fast track or the intermediate track. The transitional provisions provide that the rules only apply to cases that were issued on or after the 1st of October 2023. And there are special rules even if the issue date condition is met for claims that are personal injury claims. Now, a detailed consideration of the rules isn't possible without a detailed consideration of the fixed costs rules on both the intermediate and the fast track. In essence, the claimant will be entitled to the fixed recoverable costs, which are applicable at the stage that the claim has reached. And where a defendant fails to beat a claimant's Part 36 offer at trial, the claimant is entitled to fixed recoverable costs for the stage applicable at the date of judgment, plus an uplift of 35% on the difference from when the relevant period expired and the date of judgment. That is a massive oversimplification. Well, it's a summary, but what I must stress is that the rules are detailed. They deserve their own webinar. If that's something you're interested in, then let us know. But in essence, rules 36.22 and 36.24 are essential reading for anyone that's dealing with claims on the fixed and intermediate tracks. Once you have your head around the fixed cost regimes under Part 45 that are applicable to the fast track and the intermediate track, reading rules 36.22, 23 and 24 will make much more sense. And basically you refer back to the various tables in Part 45. But what I would stress is that if you are going to be dealing with fast track claims and intermediate track claims, that you understand how Part 36 applies to those tracks before you need to, because otherwise it's like reading a little bit like reading a foreign language. But as I say, in essence, the claimant will be entitled to the fixed recoverable costs up to the applicable stage that the claim has reached if an offer is accepted. And if a defendant fails to beat it, then the claimant is entitled to the recoverable costs for the applicable stage at the date of judgment, plus the 35% uplift on the difference between the date that the relevant period expired and the date of the judgment. So that is everything from me. I will now hand over to Evie, who's going to talk to you about tactics and tricks and tips. Okay, I'll pass you over now. Thanks, Evie.
Jasmine, could you put the next slide on, please? So it's a bit of a tall order to be asked about playing the game of settlement in a 20-minute talk on a Tuesday evening, and particularly given I am not a Harvard School of Business lecturer who can talk at length on the art and science of negotiation. But I'm going to try to give you two things from this talk. The first is I'm going to try and signpost the things you should be thinking about in your cases. And The second is I'm going to flag up some of the key features of Part 36, which you've already heard the detail from Matty and Claudia, but how those can intersect from a tactical perspective. And together, hopefully, these two things will give you some tools for being the best gladiator in this hand-to-hand combat as you can possibly be. Now, at this juncture, I should pause to say that this talk is going to involve reference to the new Gladiator film, and there will be a small number of spoilers. So you might want to turn off now if you've not read any media and you don't know the slightest thing about the plot of Gladiator and you are intending to watch it. So to start with, you've got this slide where I've put, are you Lucius Verus Aurelius or Maximus Decimus Meridius? And I just want you to think for a moment, reflect on your own style as a negotiator. Are you a taciturn Russell Crowe who inspires fear through his hardness into his opponents? Or are you a smiling assassin like Paul Mescal? And indeed, is one style better than the other? Now, as I say, there's a lot of learning online in books about the art of negotiation, which you could obviously peruse at length. But I'm going to suggest that in any piece of litigation, the approach that you take to a case about how you negotiate is going to depend on a number of factors, which are set out on this slide. And there might be other things which are not on this slide, which are relevant considerations. But I think top level, the things you're going to need to be thinking about: the merits of your case, your client's aims, your client's appetite for risk, resource allocation, who is on the other side, timing, and who are the people carrying out the negotiations. So I'm going to take you through some of these in more detail on the next few slides. But before we get to them, I've got a little illustrative, factual, exactly the opposite, fictional scenario on this slide, to try and draw out some of the issues that are going to crop up as we go. So in this fictional scenario, you act for a nather of the Colosseum, who is the claimant in a claim against the owner of the Colosseum Prop Code number 5 Limited. The claim is for loss of profits from noise nuisance caused by the rhino and the gladiators, specifically Paul Mescal, who keeps inciting the crowds and shouting loudly. The claim is estimated at £3 million. The other side's position in that litigation is, one, that the noise created was not sufficiently serious to constitute a nuisance, and second, no loss was caused. You think your client's prospects are 60-40 on issue 1 and 50-50 on issue 2. So the first thing that's going to vex you or be a relevant thing in negotiations is when to try and settle a claim. There's no right answer, but it's worth thinking about 3 different things, or thinking about it on 3 different planes. The first thing that's relevant in terms of timing is information. So what information do you have? What information does the other side have? If there's insufficient information, the parties aren't going to want to do a deal. The second is costs, and that intersects with information. By the time you have all the information about the claim, you're going to be very nearly at trial. But by that point, a very substantial amount of costs will have been spent. So there will often be a tricky dance between costs and information, and sometimes people are willing to make and accept very early offers in order to eliminate that cost risk. Then the third is psychology. Is one side or the other wedded to having a day in court? Are there personnel in the way, people unwilling to give up on the dispute? Now, I think we often tend to think about that in particular with where there are individuals. I suppose the sort of classic example is a boundary dispute. But that is not the exclusive place that you can find that issue cropping up in. Sometimes in institutions, there can be a person, a key decision maker, who is particularly wedded to the specific dispute, and they are a person that stands in the way of unlocking it all. And sometimes it can be lawyers as well. And another facet of psychology which is relevant is litigation fatigue. It is real, and I'm sure we have all experienced cases where clients start out enthusiastic for the endeavour but become increasingly jaded as time goes on. On the other hand, there can be the problem of your client, the other side, becoming entrenched. Again, I'm sure we've all had cases where a client's eyes become dazzled by a number in a pleading, and they think that that is the surefire thing what they're getting if it goes to trial, and they're not willing to accept a penny less, when in fact there are many different factors which go into the pot, and their case is nowhere near as strong, or there's some sort of issue which caps the amount that they might recover. And then there's the question of what settlement is going to look like. Now, I think this is something that's particularly significant as property litigators, because disputes are not always exclusively about damages or debt, and there are often claims which involve other components or are exclusively about property rights. The example scenario that I had up a few slides ago was very simple in the way it was described, i.e. it was just a claim for damages. But it's possible to imagine a variant on that scenario where the claimant also sought an injunction, for example, to restrain future events. Or you might be dealing with a claim where an interest in land is claimed. Will you need expert evidence in order to unlock the value of that interest so that any settlement proposals can credibly be made or evaluated? And that sort of comes back to our timing point. Or is it only going to be something that could be affected by a transfer of some land to another, from one party to another? You also see this in claims where easements are in dispute. Really, is one side going to be able to buy the other out by a monetary payment, or is the real issue going to turn on the grant of some rights or the grant of a license? And you're going to probably need to think about things as a property litigator more flexibly than you would if you were dealing solely with claims about monetary loss. So coming now to one of the other issues I highlighted at the outset, which is who's my client? What are the client's aims out of the litigation? And the reason I've got on this slide this photograph is that this is the moment in Gladiator 2 where Paul Mescal's mother is telling him who he really is. And it's meant to symbolize that you may have to help your client on a journey to realize who they are and what they really want out of this litigation. And on the other side, you're also going to have to recognize what they are, who they are, what the limitations on settlement are, what the limitations are from a litigation perspective, and in that way adapt your style and your strategy. So some of the ideas you want to be thinking about in this context is your client in a settling mood, or are they the sort of entity that simply wants their day in court? And then intersecting with that, what do they really want? It might be really simple, but it's not always really simple. For example, in the Colosseum Propco case versus the neighbour, is what the neighbour really wants an apology from the property company for not inviting them to the games, or, as we all know, for moving their bins? Or maybe really they're actually concerned about the ongoing relationship between each other and they want something more harmonious as an outcome. The role of emotion and what is really going on under the surface is really important. And then another thing you want to be thinking about is what kind of resources are being used up on the litigation. Now, I don't mean that exclusively from the perspective of how is it being funded, although that is, of course, a very material consideration. Does the client have the liquidity to fund it? But also what resources are being diverted into this litigation, whether it's cash or it's employee time or individual time. There are opportunity costs associated with litigation, and your client may well benefit from the litigation coming to an earlier conclusion rather than running all the way through to trial. There are also going to be potential reputational considerations, which one will have to think about. There's always the potential, depending on the facts of the case, that there might be a negative reputational outcome from a judgment. For example, negative judgments where findings are made about clients. But there's also sometimes seen by clients as there being a positive reputational side to litigation. There's the potential that you're seen as a tough nut to crack. Having a judgment that you can use is also sometimes relevant depending on the nature of your client. For example, is your neighbour client in the Colosseum example a landowner that owns lots of different sites against similar entities, and they want to stop this from happening across their portfolio? And then lastly, under this heading, what impact does settlement have on your client? And what impact does a judgment have? How might your client meet any order it's going to have to pay out under, or any settlement sum that it's going to have to pay? Is that going to be something that it can meet, or is it going to push them into potential insolvency? And if that's the case, then maybe you need to be thinking about how you can buy your client more time. And then on the other side of the coin, because it's not just a one-sided dance, who is the other side? Again, what is the role of emotion? Are they an individual, or are they a big corporate? What is really going on here? Your style is going to need to be different depending on who is on the other side. I.e., if Colosseum Propco, it thinks they're God's gift and they're presented by somebody who thinks they're God's gift, do you have to modify your style to be nasty like Russell Crowe rather than nice like Paul Mescal? So on the other hand, if it's an individual who your client has allegedly wronged, is the tactic of being nice going to get you're going to get more flies with honey than with vinegar? Then if you're seeking money from, or your claim is for damages from the other side, what about their assets? Do they have any assets? What is the value of a judgment, or indeed a costs order, if there's no way of obtaining payment? So is Colosseum Propco an SPV, or is it an entity with big pockets? And this point can sometimes be a very great tool from a negotiating strategy, i.e., there's no value in you going to trial because you're not going to get anything practically out of this. So you're throwing good money after bad. And then a slight variant on that theme is, if there are assets, what form are they in, and where are they? So in our situation, we know that Colosseum Propco owns the Colosseum, but is it charged to the hilt? And even if it is not, is your client going to have to spend further time and resources obtaining a charging order and then an order for sale? Or are the assets offshore in other parts of the Roman Empire, where enforcement is going to be difficult or impossible? And then turning next to one of the most important things, I think, when you're thinking about settlement is appraising the merits. I called it appraising the merits earlier, but really maybe the better way of describing it is valuing your claim or the obligation. Now, on this slide, I have a decision tree. I can't take credit for this idea. It's something I've learned about from Liz Jones, KC at Searle Court. I think it's a wonderful thing to use, in particular, if you're preparing for a mediation or a negotiation. It gives you a mathematical appraisal of your upside so that you can assess where to settle at. And it really also makes you think about the downsides and the risks. And it forces you and consequently the client to think on the negatives as well as the positives and see the whole matter holistically. Another thing I like about it is it's a little bit like the adult version of a Miss Cosmo quiz. So I think that's fun. On the left-hand side, you have the Paul Mescal square, which is the decision you need to make. And your options here are you're either going to court or the bottom corner you're going to settle, and you're being offered a settlement at £1 million. So you need to decide whether to take that. On the top is what would happen if you went to court. Now, if you go to court, the first issue is, are you going to establish whether the conduct was a nuisance or not? And we earlier on saw that the risks of that are, or the prospects were 60-40. So you've got the yes node at 0.6 to allocate the 60% prospects. So if it were established, you would then move on to the loss. And the next issue would be proving your loss. And we saw earlier that the prospects of that were 50-50. So again, your yes node, you go up to the box after the arrow, and that is £5 million, and that's your likely outcome. And that's a figure I've allocated to the upside, which is the upside from today when you take into account interest up to today, because today is the date of the decision, minus the costs you will have to spend out from today and not get back. Now, if you go back a stage, you succeed on issue one, but you lose on proving the loss, you get a negative £1 million figure. And that is the downside if you lose, which is that you pay the other side's costs and you can't recover your costs. And that's been assessed, in this case, hypothetically, at £1 million. And again, if you go back to node A, if you lost on issue one, you would also be paying the other side's costs and not recovering your costs. So you then have to work along the lines to get the value of the claim. So if you start at the £5 million figure and you go back to node B, you've got £2 million there. And what that is you've worked out the 50% of the £5 million figure, and then you've deducted 50% of the £1 million figure. And then you go back a stage further and you work out 60% of the £2 million figure and deduct 40% of the £1 million figure. And then in node A, you get the £800,000 value. And that is effectively the value of the claim at today's date. So when you then look at the settlement figure of £1 million, it looks around the right sum to settle at. You can obviously keep this flexible, add in lots of other different limbs to it, change the figures depending on different risks, different factors. But you want to be thinking about this, whether in this form or in another, but I suggest this is quite a useful little tool. And you also probably want to be thinking about the other side's decision tree, because you want to be thinking about how they will appraise the risk. So that was a sort of high level canter through some of the themes, ideas that you want to be having in your mind when you're thinking about settlement more generally. But you're probably asking, how does this all fit within the scope of Part 36, or how does it interact with the mechanics in Part 36 is probably the better way of saying it. And there are, I'm sure, other ideas, other points to crop up, but I've highlighted on this slide 6 things that occurred to me when preparing for today. So the first thing I thought about is early offers. As Claudia and Matty outlined earlier, there are very significant consequences to both accepting an offer and either beating it at trial or doing just as well if you're a claimant. So from a claimant's perspective, if you're making a Part 36 offer at an early stage in the litigation or even pre-commencement, you can put yourself in a very strong cost position because of the indemnity cost consequences. You can also put yourself in a really strong cost position on the interest on costs. You don't often see people applying for interest on costs, but it can be extremely significant if you have very long-running litigation, which lasts, a number of years. The costs will be large, and therefore the interest on the costs could potentially be very large. So that can give you a very significant tactical advantage, as well as a very considerable benefit if your client is successful or has the offer accepted. But of course, and I mean, I include the client in that, might not have done the work to have all the information necessary. So going back to our Colosseum example, you might not yet have the expert evidence for the valuation of the loss of profits claim. And that might mean that the value of your claim is actually over or understated. You also might not have relevant information from the other side. So it might be very difficult at this juncture, by which I mean either pre-issue or very early on in the litigation, to know whether an offer is or is not pitched right from that perspective. And that might have very significant impact on whether you actually acquire the cost protection that Part 36 would give you. And it also might mean that your client might be settling at an amount that is lower than what they actually might ultimately get at trial if they were to go there. Although for reasons which we've already covered, it might be that there are countervailing benefits, which means from your client's perspective that it's worth it, and it's a very good time to offer. There's a sort of similar thought process that one would be having if you were acting for a defendant, albeit of course without the indemnity cost protection, but with an additional tweak, which is that for a defendant, the consequences, the automatic consequences on judgment are from the expiry of the relevant period. So if you make an offer very late in the course of litigation, your costs protection won't start until very late. You also might be at risk for that earlier period. And similarly, if it is accepted, the costs up to the relevant period might be very significant. So when you make your offer for Part 36 can have real practical ramifications. And there's, of course, the thing to think about, which is if you pull your offer because you find out information down the line, you're not going to get the cost protection. Then the second point on the slide is, are you intending to mediate? And if so, what is the relationship that any Part 36 offers are going to have with mediation? In a case where mediation really would be helpful, for example, there's some issue that needs to be unlocked, like one party hasn't appraised their merits correctly, or there needs to be some reality checking done by the mediator, or there are really difficult personalities. Any written offer in advance, if you're thinking we're really going to need to mediate, any written offer in advance is going to be the anchor, i.e., if you're the claimant and you say in advance, we'll accept £1 million for settlement of our claim, Colosseum Prop Code, pay us that, that's going to be the starting point. And you're not going to get more than that at mediation. So really you want to be thinking about the shape of the case, the phases down the line from an early stage. If there has been a Part 36 offer, another way of thinking about how it might impact on the mediation is, how does it impact on the costs, upsides, downsides? If you've made a really strong Part 36 offer, which would be something that the defendant is really going to struggle to beat at trial, how is that going to impact on the way in which they interact with the bonus, the interest? If you're And then lastly, on the thoughts about mediation, if you've been at a mediation which has been unsuccessful, don't think of it as a failure. It's been an information gathering exercise. You've found out, hopefully, throughout the course of the day, the other side's final position, what their walkaway figure is. And if you haven't done a deal, you want to be at that stage making a Part 36 offer for your bottom line, your walkaway figure, and to give yourself the protection from that point going forward. And then the third point on this slide is later stage offers. Notwithstanding what I've just said about the benefit that there can be of an earlier offer, a later stage offer can also be useful. I did a big trial a few years ago where my client made a Part 36 offer 22 days before the trial, which wasn't accepted, and which we then beat a trial. So my client then got the uplift, indemnity costs for the trial, and interest on the higher rate. So it was a very worthwhile exercise. Obviously, all the things that Claudia said earlier about late stage offers are significant. So you need to be thinking about, if you're making a later stage, i.e. one that's sort of closing in close to trial, are you going to be able to serve the offer in time, given the deeming provisions in Part 36 and Part 6, so that you don't get caught out by the fact that you are actually under 21 days and permission is required to accept it, and you don't get the automatic cost consequences. My fourth point is, does Part 36 actually suit what you're trying to achieve by settlement? Given the form of Part 36 being merely that it needs to be in writing and the other points that Matty and Claudia picked up on, it can be very flexible. But the nature of what you might be dealing with as a property litigator might involve something like the need to transfer land or grant rights. And in those circumstances, you're going to be wanting to think about the formalities, whether in Section 2 of the Law of Property Miscellaneous Provisions Act 1989 or the Law of Property Act 1925. There are terms about express declarations of trust or transfers of subsisting interests in trusts of land. So you want to be thinking about that. Obviously, correspondence can be sufficient provided that it is signed. But will your Part 36 incorporate all of the terms? You really need to be careful about that, I think. And there's also authority, a case called Orton and Collins from 2007, EWHC 803 Chancery, where the parties had made and accepted an offer to settle using Part 36 involving a disposition of land, but not a single document incorporating all the terms. In that case, the court ordered the parties to sign a single document. So you need to think about this really carefully and be very careful about using Part 36 for something where you're going to be disposing of an interest or granting rights in land, say for perhaps the most simple cases, because you might be opening up a can of worms. The fifth point is, who is the claimant? And that arises in cases where you have a claim and a counterclaim, because who is the claimant will be significant for the purposes of the consequences of acceptance and after judgment. There is authority which says that this is a question of construction. You want to look at a case called Van Ord and Allseas, 2016 1 costs LO1. But you can really mitigate the danger in all of this if you are clear in expressing it as a claimant's offer, whether that comes from the claimant or the defendant. That is particularly important if the offer is a £0 Part 36 offer, because that is probably going to open up some questions about who is the claimant and who is the defendant in terms of receiving a payment and paying a payment. And if you haven't expressed clearly that it's a claimant's offer, the court is going to be looking more holistically at the other things that are said in the offer. Last, something you see people doing and can be quite effective is simultaneous offers. For example, where you have something like Matty described earlier, where you want to forego your costs as a claimant and you've got the sort of question mark about whether that's going to fall within Part 36, or you want to do a drop hands, as well as something you could do is you can have your Part 36 be the stick and the other offer, the call to bank offer, be the carrot. So that's something that's worth thinking about when you're thinking about structuring your offers, i.e. it's not a Part 36 or call to bank, it could be both of them used tactically together. So to draw this this talk to a close, I've borrowed Paul Mescal's line from Gladiator 2. I'm hoping that after today, we do not find ourselves in a position where we are settlement is not. But as I say, how you approach settlement, and indeed if it is something that's even on the table, is going to depend on the facts of your case. And it's always worth thinking about who your client is, what they want to get out of the litigation, and who you're negotiating against, and what the value of the claim or obligation is. And only once you've done all of that, and you've got a clear idea of the lay of the land, can you appraise what offers to make, and whether, and if so, how to use Part 36. That's me drawing to a close, and I think we have about 10 minutes now left for questions. So one of the attendees has asked, can a party make a Part 36 offer in a business lease renewal case? Matty or Claudia, do you have any thoughts on that?
I can jump in on this. Yeah, I don't see why not. I haven't actually got experience personally of a Part 36 offers being made in business renewal cases. Mine have all settled before I've got as far as, especially a disputed lease renewal case. So I don't see why not, but I don't have personal experience of it. I don't know if Evie or Claudia, if you've got personal experience of Part 36 offers being made in that context.
I am aware of them being made in that context, yes. Yeah.
I suppose it's probably much less common because, well, especially in where it's an unopposed renewal, because you're going to be trying to hammer out the terms. But as you say, there's no conceptual barrier. I think it's probably quite unlikely that you'll find it coming up often. What was the example that you had, Claudia? How was it being used?
Well, I to be honest, I can't speak with a whole lot of detail on it because it was while I was a pupil, so I can't say that I was privy to the offer. But it was in the context of I know that several Part 36 offers were made in quite a hotly disputed business tenancy renewal case, which went to trial. And indeed, offers were being made while the trial was going on as well.
Right.
None were successful, unfortunately, but they were all made, and they tended to relate to specific issues. So I believe offers were made in relation to both the quantum of the rent as well as particular terms, such as the certain caps on service charges, for example, and the quantum of those caps.
Another Another attendee has asked, who can make a Part 36 offer? Does it have to be an officer of the court, or can it be made by a litigant in person or their agent? Claudia, do you have any thoughts on that?
Sure. So there is no rule to the effect that a litigant in person cannot make or accept a Part 36 offer. In fact, if you look at the Judicial College guidelines for, or well, a handbook for litigants in person, it makes clear that litigants in person, like any other party, is encouraged to make offers to settle, accept offers to settle, and they are given specific guidance on how Part 36 works. Another point to note is that a protected party can also make and accept a Part 36 offer. So, for example, a child or somebody who lacks mental capacity within the meaning of the mental health legislation. Although in the case of a protected party, either an offer or an accepted offer will not actually be effective unless it is specifically validated by the court pursuant to CPR 21.10. But generally, Part 36 offers may be made by a party to the litigation, whether or not they're professionally represented.
Thanks, Claudia. Matty, we have a question which is, what would I have to consider in a dilapidations dispute where Part 36 is going to be used?
Thanks, Evie. So I think Part 36 can really helpfully be used in dilapidations disputes, especially, I mean, from a tenant's perspective, usually at the end of the lease, there usually is some delapse. So once you've got to a point where the landlord has got their schedule of dilapidations and you've got a counter schedule, you, as the tenant, will usually know by that point whether or not the landlord's claim has got any legs. If there is some disrepair, then as the tenant, you're on the back foot to a certain extent, because if they issue proceedings on the basis of the schedule, the various schedules, you might already know that unless you settle, they're going to succeed at least on liability. So I think for tenants, especially in dilapidations claims, it's Part 36 can be a useful tool, especially, for example, if the landlord hasn't bothered to get any valuation evidence, so they're not going to be able to show that there has been a diminution in value of the reversion, for example. At that stage, you might put in a Part 36 offer to the extent, sort of at the level that your surveyor accepts that there is delapse, offer to pay that, and to the extent that they don't accept that, then they're not obviously at risk of the Part 36 consequences. So I think in relation to dilapidations claims, you really want to evaluate the evidence that you've got, especially as the tenant, because you're on the back foot until you put in a Part 36 offer that you're confident the other side isn't going to beat at trial. I hope that sort of answers that question.
I think so. We've had a question which is, if a cap on costs in the proceedings is imposed by the court, will a Part 36 offer permit the successful party to recover costs beyond the cap of costs? I think that's asking about where there's been a cost management order made in a Part 7 claim under the multi-track, which cost management applies to by virtue of Part 3. The effect of cost budgeting means that the court has set the amount that's recoverable for costs which are payable on the standard basis, but not the indemnity basis. So if the question is, will you, if you're a claimant and you achieve an outcome at least as advantageous as a claimant's offer, will that permit you to recover over and above your budgeted costs? Yes, because the indemnity costs basis is not what is reasonable and proportionate, it is what is reasonable, meaning reasonably incurred and reasonable amount. You could obviously also achieve that by arguing there is another factor which takes it into an indemnity costs world. But if you're a defendant and the claimant fails to beat your offer, you don't automatically get indemnity costs. There has to be one of the features that would take it outside of the norm, which is the language in the Excelsior case, which is what you want to be looking at if you're thinking about indemnity costs more generally. So you don't automatically get costs that are over and above the standard basis. I think that covers that question, unless there's anything Matty or Claudia think that they would like to add on it.
No, nothing from me. I think that covers it, Evie. Do we have time for one more, maybe?
I think probably. What about, is the defendant liable for the claimant's costs if the defendant makes a Part 36 offer which is accepted within the relevant time?
Claudia, do you want to take that? I mean, I'm happy to take it.
Sure. No, this is quite, this is perhaps something I should have covered in my talk, but essentially, in the event that a valid Part 36 offer is made and then accepted, then you get then Rule 3613 kicks in, and what that says is that the claimant will be entitled to their costs that they've incurred in the proceedings up to the date on which they served notice of acceptance of the offer. So essentially, the defendant will be paying the costs of the claimant at that point. And it's just worth noting that if the parties are unable to agree on what those costs should be, then the court can determine it and will ordinarily assess it on the standard basis. But of course, that is subject to any the wider jurisdiction discretion of the court in determining costs as well.
Thanks, Claudia. Thank you all for attending today's webinar. We hope you found it useful and that it provided a helpful intro to the world of Part 36 and some hints and tricks for how you might use it all to your advantage. As I said earlier, you will be sent a copy of the slides and the recording after this webinar. Otherwise, have a lovely evening.